The prosecution, considering that the accused persons are first offenders, but asked the court to take into account that the offences the accused committed are serious corruption and felony crimes for which deterrent sentence ought to be imposed. Yet the court that the offences of fraudulent acquisition of public funds was in respect of public funds that belong to pensioners who contribute to NSSF, and the privilege led to erosion of public confidence in government institutions charged with the management of those funds. The prosecution requested the court to impose a mandatory sentence under Section 48(2) of Anti-Corruption and Economic Crimes Act, order the complainant to be compensated for the loss as required under Section 54 of the same Act, and also impose a restriction against the accused persons from holding office for the next 10 years. There was commitment demonstrated through their actions to defraud NSSF through Discount Securities Limited, and thus they are equally culpable as the seventh accused. I find that there is good reason to hold them equally culpable, for if it were not for them, these horrendous crimes would not have been committed. As for the first accused, he was fully aware of this criminal intention and he enabled them to execute it through his actions of deceiving NSSF, which was his employer, instead of assisting it to avoid making those fraudulent payments. He abused a position of trust and authority, which is a serious aggravating circumstance, for if he was furthered, the public would not have lost such a staggering amount of money. I concur with the prosecution that the offense is called for stiffer sentence. The sentence shall be as follows. Count 1, conspiracy to defraud, contrary to Section 317 of the Penal Code. Accused is sentenced to a fine of Kenya shillings 1 million, in default serve 2 years imprisonment, right of appeal 14 days. Count 5. This is the offense of deceiving principal, contrary to Section 41(2), as read with Section 48 of the Anti-Corruption and Economic Crimes Act. The offense shall be punished in 2 limbs, Section 48(1)(a) and 48(1)(b). Sorry, 48(1)(b) and 48(1), yes, 48(1)(b). 48(1), yes, 48(1). Under Section 48(1)(a), which provides for general sentence, I'll sentence the accused to a fine of Kenya shillings 1 million in default serve 3 years imprisonment. Under Section 48(1)(b), the Act states, and I quote, an additional mandatory fine if, as a result of the conduct that constituted the offense, the person received a quantifiable benefit or any other person suffered a quantifiable loss. So the operative word here is any other person suffered quantifiable loss. Although demonstrating that the first accused received quantifiable benefit, it was crystal clear that through his actions, NSSF lost a staggering 1,201,143,372 shillings and 40 cents. Under Section 48(2), the amount of the fine payable shall be as per subsection 2A, which is mandatory fine shall be equal to 2 times the amount of benefit or loss in subsection 1B. In this case, therefore, the first accused is liable to a fine of Kenya shillings 2,402,286,744 and 80 cents. In default, first accused shall serve 9 years imprisonment, right of appeal 14 days. Count 4. For the offense of conspiracy to defraud, the fourth, fifth, and sixth accused shall pay a fine of Kenya shillings 1 million in default serve 2 years imprisonment. Count 3. They were jointly convicted for the offense of fraudulent acquisition of public property, contrary to Section 45(1)(a), as read in Section 48(1) and 2 of Anti-Corruption Act and Economic Crimes number 3 of 2003. As with the first accused, the offense is punishable under 2 limbs. In the first limb, I sentence under Section 48(1)(a) the fourth, fifth, and sixth accused to a fine of Kenya shillings 1 million in default serve 3 years imprisonment. I direct that the seventh accused shall equally pay the said amount of fine, which shall be satisfied by the statutory manager from the assets of the seventh accused, if any. Under subsection 48(1)(b), it is clear the actions of the fourth, fifth, and sixth accused caused NSSF to suffer loss of Kenya shillings 1,201,143,372.40 by facilitating the seventh accused to acquire the said money through sending NSSF false contract notes and demand letters on the behalf of discount securities. Discount securities, on the other hand, not only caused the loss of NSSF but also acquired the said sum or benefit. So, for the fourth, fifth, and sixth accused, the Kenya shillings 1,201,143,372.40 is to be multiplied by 2 and apportioned equally. Whereas, for the discount securities, both loss and benefit are to be added and multiplied by 2. Consequently, fines against fourth, fifth, and sixth accused shall be as follows: amount of quantifiable loss multiplied by 2 divided by 3. Each accused, fourth, fifth, and sixth accused, shall pay a fine of Kenya shillings 800,762,248.27 in default, each to serve 9 years imprisonment. Right of appeal 14 days.